Let's see. Seems that we have everyone here. Mr. Meacham, have you got your audio all worked out, or are you going to be speaking through your cell phone?
If you can hear me, I'll be going through my phone, Your Honor.
You're coming in loud and clear, counsel. Okay. Did you
Thank you very much.
Time for your rebuttal, sir?
Yes, sir. 5 minutes.
Okay. All right. With that, we have the panel, have both both lawyers. We are ready to proceed. Please go ahead, Mr. Meacham.
Thank you. May it please the court. My name is Bart Meacham, and I represent Howard Avenue Station, LLC, and Thomas Ortiz, the third-party plaintiffs in the lower court, the appellants in this action. I'll start by talking about what this appeal is not about, or I should say should not be about. And Mr. Campion, Richard Campion, the appellee, is trying to make this about, which is whether there is service of process on him. This appeal should not be about whether there is service of process, because the lower court did not dismiss the action with prejudice for purportedly failing to serve him. This action was dismissed with prejudice based on the statute of limitations. And by the way, a case cannot be dismissed just for the failure to serve. A case can be dismissed for the failure to serve within 120 days under Florida Rule of Civil Procedure 1.070J. But again, that did not happen. And that was not litigated. A purported failure to serve Mr. Campion within 120 days was not litigated in the lower court and was otherwise not ruled on by the lower court as a reason or a ground for dismissing the action against him. And if the lower court had dismissed the action against Mr. Campion with prejudice for failure to serve him within 120 days, that would have been reversible error, since Mr. Campion cannot have it both ways. A party can't get a dismissal with prejudice without being served with process. And I will cite there's two opinions of this court, Synchron Inc. versus Kogan, which is 757 7 2nd 564, a 2000 case, and Griffin v. Slade, this court's opinion, 2012, 95-7 3D 982. And that's basically absent of service of process or a waiver, an order of judgment on the merits is void. With that being said, it would have been reversible error for the lower court to dismiss the action against Mr. Campion, even without prejudice, since the statute of limitation period as to the claims against him, as worded, had expired as of April 27, 2016. And I'm quoting from three cases before this court for that. That's 884 Southern 2nd, 1065. That's Brown v. Ameristar, a 2004 case. And Kohler, Kohler, the VEGA-MALTES, that's 838 Southern 2nd, 1249, a 2003 case. And then the oldest is Miranda v. Young, 19 Southern 3D, 1100, a 2009 case. I'm sorry, that's, I guess, the newest one. And this is a quote. It is ordinarily an abuse of discretion not to allow additional time for service of the summonses, even in the absence of a showing of good cause or excusable neglect, if the order of dismissal is entered after the statute of limitations has run. And another quote, where the statute of limitations has run and there has been no showing of good cause or excusable neglect, discretion should be exercised in favor of giving the plaintiff an extension of time to accomplish service. And on top of that, before the lower court could have properly dismissed the action against Mr. Campion, which again didn't, for failure to serve him within 120 days, which again didn't happen, but before it could have, there would have to have been a hearing as to whether Mr. Campion waived service of process, which there was not. There was no such hearing, since the court did not dismiss the action against Mr. Campion with prejudice for failure to serve Mr. Campion. But if there had been such a hearing, it would have been shown, as stated in the reply brief, that Mr. Campion waived service of process in three ways or times. First, Mr. Campion waived service of process on May 28, 2010, by voluntarily filing and serving a motion to dismiss counterclaims and third-party claims. And at that point, I hadn't
In
even
that
had,
motion-
it was
in that
16
motion,
days
sir,
after it was filed.
Mr. Meacham.
He just
in that-
voluntarily
in-
files a motion
Mis-
to dismiss.
Mr. Meacham, excuse me.
Second, Mr. Campion waived service of process, the second time on March 1st, 2016, by doing the same thing, by voluntarily filing and serving a motion to dismiss amid his counterclaims.
Mr. Meacham,
And-
Mr.
Yes.
Meacham, can you hear me?
Yes.
Can I ask a question?
Yeah, please, I'm sorry, I couldn't hear you. Yes.
When he filed his motion or other pleading, there was a statement where he pointed out that service had not been affected.
Right. And what
Why
I'm
would that-
saying is
why would
that
that then constitute a waiver of the defense?
because the case law, and it makes sense because I understand it because it did happen, and I appreciate a good chess move because I grew up playing chess. But the problem is that if a process server shows up on a Sunday or there's an issue with process, then you file a motion to quash and you raise that issue, and as long as you raise it, it's been preserved. But when there has been no attempt, the second time it was actually filed on the day I got the summons issued. So what I'm saying is the case law is clear that you can try to put that in there, that there's a service of process issue, but if there's been no attempt to serve you, what you've done is you voluntarily filed a response before the party. And so
I'm having
what I
trouble with
see-
that. I'm wondering if the first thing I see is a motion that raises a question about service, the thing to do is hurry up and get your process server out there and get that issue off the table.
Well, if you haven't even had the chance to do that yet, and you've got 120 days, I'm saying that there was no reason for Mr. Campion to file anything because the summons had just been issued that day. And I will
So are
move
you
on to the.
suggesting that by filing something in the circuit court, he's obviated your need and your client's need to have him served?
I would say that if there's been an attempt to serve a party, because you can raise insufficiency of service of process through a motion to quash. It was served on a Sunday, it was done wrong. But my understanding of the case law is that if you just voluntarily, before the other party's made any attempt to serve you, just voluntarily file something, then that's a waiver. And again, this one,
Mr. Meacham, it's not clear to me when I'm reading through this as to what the story is, as to whether he was served, whether an attempt was made to serve. All I see is he filed this motion that included that claim. And, beyond that, it's hard for me to discern what all was going on behind the scenes to serve him, if at all.
well, the first time the summons had not been issued, and within 16 days of filing the third-party claims that brought Mr. Campion into the case, named him as a party, within 16 days after that was done, there was just voluntarily filed a motion to dismiss and raised an issue with service, but there wasn't any issue to raise because there had been no attempt to serve him. Okay.
Okay.
And
I want to go back
that,
to my question because I'm not sure I got an answer. And I think it's a yes or no. Are you suggesting that if somebody files an action and somebody files any response at all, even if it's a motion to dismiss, that obviates the need for service?
if there has been no attempt to serve, the answer is yes. My understanding, if it just voluntarily files a paper when there's been no attempt whatsoever to serve the party, let's say that they go online and see that there was a lawsuit filed against them and go home and type out a motion and file it with the court and say, I haven't been served. I think that's voluntarily filing something that would be a waiver.
Even a motion to dismiss for lack of jurisdiction or anything else. You're saying anything they filed, then that's it. You're now as good as served and you move forward before that court.
Well, you preserved all the other arguments. If you're in Wyoming and you're saying there's no the long arm statute, you don't fall under that. I mean, everything else is waived. I mean, the only thing that I'm saying is waived is the requirement to serve the party. You can say there's no jurisdiction over me, there's no personal jurisdiction, there's no subject matter jurisdiction. The only thing I'm saying is waived is that if you voluntarily file something before there's been an attempt to serve you, then you've waived the service, but you haven't waived anything else. Venue, jurisdiction, that's all I'm saying. And I hope I've answered your question sufficiently with respect to that. And I'll move to really then the second time. So again, that was on the exact same day. I hadn't even had a chance to serve. So I think I think another way that this could come into play, and again, there wasn't a hearing down below on this issue, and so the court did not even dismiss the case because of service of process. But I think if there was an argument that, well, you didn't serve within 120 days or what have you, I think you could be stopped. Maybe it's not a waiver, but you could be stopped from raising that by the fact that you just jumped in the case voluntarily. But I would say that what's not in dispute is that, and again, I would cite just as far as the voluntary, it's Aviel, A-V-A-E-L, the Sechrist, S-E-C-H-R-I-S-T, out of the 3rd District 2020 case, and citing Anthony v. Gary J. Rotella and Associates, PA 906 Southern 2nd 1205, 4th DCA 2005. But what you can't do is if you jump into the case and ask that it be dismissed with prejudice, then that is definitely a waiver of service. When you're trying to get an adjudication on the merits, and that case is it's OY v. Carnival Cruise Lines, Inc., 632nd Southern 2D 724, a 3rd District case, 1994. And it's finding that OY did not waive any objections to sufficiency of process or service of process. Its filings did not go to the merits of the case. So the reverse is that if you're trying to win on the merits, then it is a waiver. And then there was this citing to Zimmerman v. Weinberg, 557 Southern 2nd 193, 4th DCA case 1990. They held that defendant's motion to dismiss for failure to prosecute acted as a waiver of claim of lack of jurisdiction, because the term merits implies a consideration of substance, not a form, of legal rights, not of mere defects of procedure or the technicalities. So in this, and then there's McKelvey v. McKelvey, 323 Southern 2nd 651 out of the 3rd District in 1976. And it says filing motions, quote, involving the merits, end of quote, or quote, going to the merits, end of quote, is a waiver of jurisdictional challenges. And so if a party does, like Mr. Campion did, the second motion to dismiss in response to the amended complaint, he sought a dismissal with prejudice based on the statute of limitations. And that's what he's got. He's got, as it stands right now, an adjudication that he cannot be sued for that. It was barred with prejudice. If should we not win on appeal, then this case is over and done with. And so he sought to prevail on the merits, and that would be a waiver as well.
Mr. Meacham,
but again, the trial court.
Excuse me, Mr. Meacham.
Yes.
Could I shift your thinking just for a moment? The
yes.
Claims, as I understand them, against Mr. Campion are identical to the claims asserted against a Dubliner. Is that right?
Yes, it is, and it's not claims for indemnification under 1.080. It's bringing in a third party. Yeah, sorry.
Well, I guess that's my question. Is this the claim against Mr. Campion? Is that a proper third party complaint?
Yes, because if you commit, a person cannot commit torts and hide behind the corporate veil or shield. So the Dubliner was the plaintiff.
But I thought the third party complaint rule was to bring someone in who would be responsible to indemnify you or to seek.
Well, there's two things, and that's the argument of Mr. Campion, and there's a tipsy coachman argument involving that exact issue, and the problem is that there's Rule 1.180, which Yeah, a third party, which allows you to bring in a third party claim who may be liable. But there's 1.170H, which permits or even requires that a party be added to a counterclaim. Quote, when the presence of parties other than those to the original action is required to grant complete relief in the determination of a counterclaim. So when we've got the claims against the Dubliner, and then we've got, because they're intentional torts, the claims against Mr. Campion because he can't hide behind the veil. So, and I'll cite to the cases which talk
but
about
that's
complete.
That's to Mr. Meacham. That's to make sure you have all the parties that are needed for complete relief. And it seems to me your claims against the Dubliner are freestanding, irrespective of whether Mr. Campion is a party or not.
Well, my client would not be getting complete relief just to sue the Dubliner. My client's claims are against both parties. But just to the argument of Mr. Campion is that you can only go under Rule 1.180 and 1.180A. And I'm saying, you can go under 1.170H, which
you need to wrap
permits.
Take your time.
Excuse me?
You are beyond 15, so you should wrap this one up.
Okay, I will stop and I'll pass. Thank you.
Okay. Counsel Bush, you are, there we go. You've unmuted. Thank you.
Thank you, Your Honor. May it please the court. My name is Gwendolyn Bush and I represent the appellee Richard Campion. There is one undisputed fact in this case, and that is that my client, Mr. Campion, was never served with process. Service of process is required for a court to obtain jurisdiction over a party, and in order for the court to exercise any jurisdiction over a party. And what the appellants are trying to do here is ask the court to create an exception to the rules, constitutional rules, statutory rules, that service of process and jurisdiction are required. Appellants want you to create an exception to these requirements to excuse their failure, simple failure to serve my client. They had 6 years to do it. They were on notice when we filed our motion to dismiss back in May of 2010 that we were contesting service of process and jurisdiction. I don't know why they didn't serve. They never got a summons issued back on the original counterclaims and third-party claims filed back in 2010. If you look at the record before this court, there's no reflection of any summons ever being issued, and certainly no reflection of any service of process ever being accomplished. As a consequence, my client was never brought into this case. There was never any jurisdiction obtained over him by the court. So when they filed their, what they call amended third-party claims 6 years later, my client had never been a part of the case. So there's nothing that the claims could relate back to. My brief goes through all the arguments. I know Mr. Meacham didn't raise all of them in his time, but the Caduceus case does not apply here because there was no issue of jurisdiction or service of process. The court there allowed the relation back because the parties that were sought to be added as defendants were already in the case as third-party defendants on a proper third-party defendant claim under Rule 1.180. There was no issue whatsoever of jurisdiction that was raised at all, no issue of service of process raised at all in that case. That case literally has nothing to do with the situation that this court is looking at today. So it's really pretty simple. By the time the amended third-party claims were filed in 2016, statute of limitations had long run against on these claims. Since Mr. Campion was never in the case, never brought in properly by service of process or jurisdiction, so the jurisdiction never obtained over him, they can't maintain the claim. And that's what the trial court found. As far as waiver, my client didn't waive anything. He didn't waive service of process.
Ms. Bush, could I interrupt you for a moment? When the claims were filed, were they timely?
The original third-party claims?
Yes, ma'am.
Yes.
Okay, so if I understand your position, not only is I have to serve the party within the statute of limitations. Is that your position?
Yes. The cases that we cite in our brief, I think, are pretty clear that you can't just file a claim and never serve the party. The court never has jurisdiction. If that was the case, nobody would ever serve anything because they wouldn't need to. There would always be this, oh, after the statute of limitations expires, well, I didn't need to serve him. Well, there's no case that says that. I haven't seen a case. I haven't seen Mr. provide a case. In fact, the cases are quite to the opposite, as we stated in our brief. That service of process is required. Synchron case, the Griffith.
Service process would be required for personal jurisdiction.
Yes, Your Honor.
The filing of the lawsuit would establish whether or not the court had subject matter jurisdiction. Is that right?
Yes, Your Honor. I think that is right. Yes, we're not talking about subject matter jurisdiction, only personal jurisdiction. And so if a party is allowed to file a claim, never serve it, like just for example, as they did here, they sued we filed originally, the Dubliner originally brought this case. Mr. Campion was never a party plaintiff. They filed a counterclaim, the appellants filed a counterclaim against the Dubliner. And then these supposed third party claims that are at issue here, which are not proper under Rule 1.180, because they did not allege a claim for indemnity, contribution, or subrogation, which they could never do, because my client can't be liable to them for the actions that they took to harm the Dubliner.
To measure the operation of the statute of limitation by at least one, looking at the date the alleged claims arose, and then two, looking second at the date that the lawsuit was filed, and then measuring the time span between those two?
I'm sorry, on the first part of your question was cut off.
To determine the statute of limitations, to determine whether it has expired, do we not look at the date the claim accrued and then measure that against the date that the lawsuit was filed to determine whether or not the statute ran?
I think that is correct, Your Honor.
All right. So in that process, there's nothing there about measuring the date of the service of the process to bring the defendant's personal jurisdiction within the court. Is that correct?
Well, I don't.
The question is then, when he filed it, does it relate back to the filing of the original action to bring it within the statute? Is that the correct operation here? If it's not, please tell me what the correct operation might be for measuring the statute of limitations. In other words, if it doesn't relate back and it's filed 6 years and statute of limitation is 4, then it ran.
That's correct. And that's our position, Your Honor, because it can't relate back because he was never a party to the case. He was never brought in by service of process. And the Caduceus case makes it clear you've got to be a party to the case at the time, before the statute of limitations expires. And that is not the case here.
So the argument is when they filed the original answer and the so-called counterclaim, which if I recall only says he was an employee, he was never served. So then when they filed it, there was nothing, do we look at, if I look at what was pled, it's going to be difficult to find a relation back, but am I looking at the date the lawsuit was filed, the cause of action? Or am I looking at the whole thing because it was filed and never served? Is that what you're saying?
Yes, Your Honor. You can file a complaint, but you got to serve it. And they never served it.
Well,
They
I
never
understand
served my client.
personal jurisdiction.
But that's where I was a little confused. It seems to me for statute of limitations purposes, the cause of action has to be filed within a certain period of time. And I view that as a distinct issue from the questions to whether or not I ever acquired jurisdiction over a party.
Yes, Your Honor, that is a separate question, but they alleged in their so-called third-party claims, which are not proper claims, that the events had occurred in 2007 and 2010 at the latest. They've already agreed in their papers that there's a 4-year statute of limitations. So Mr. Campion is never a party to the case in 2010 or any time thereafter. By the time they file this amended counterclaim, or amended third-party complaint, which they never served either, it's 6 years later. So these claims are barred under the statute of limitations, which everybody agrees is 4 years. So the trial court was correct in finding that the claims are barred based on the statute of limitations. Now, this argument about adding him as a party under 1.170H, they did not raise that in their initial brief. So that should not be considered here, Your Honors. That's under your own case law, Martinez versus IPOX, 925 Southern 2nd, 448 and 450 at 450, second DCA 2006, citing another second DCA case, Plickta versus Plickta, 899 Southern 2nd, 1283 at 1287, second DCA 2005. So, with all due respect, that should not even be considered here. There is a motion for rehearing that I think is part of this appeal, although there hasn't really been much argument about it. No transcript was provided on that, so this court should not be considering that either. I think the case just comes down to service of process, which is undisputed, never happened. Without service of process, there's no jurisdiction. By the time they file what they call amended third-party claims, they're actually first-time claims against my client because he was never in the case. So, and they're claiming these events occurred in 2007 and 2010. Under the statute, any statute of limitations, they're barred.
In the circuit court, the asserted causes of action, are they not within the jurisdiction of the circuit court?
You mean the subject matter jurisdiction?
That's correct.
Well, yes, they would be.
So we know the trial court had jurisdiction over the causes of action. So the question, does it become when they were filed? I mean, I'm trying to find out. I think I'm trying to follow up with Judge LaRose, who was trying to follow up me. I want to make sure as we speak, we're using the specific type of jurisdiction that you are claiming the trial court lacked or did not lack. I mean, if it had subject matter jurisdiction and it was filed outside the statute, that's a defense that says that you can't bring it. It doesn't necessarily encompass when the service of process took place. They could have filed a lawsuit naming him a defendant, waited a couple of weeks, amended that cause of action, and then went out and served him, and you might still have an affirmative defense of the expiration of the statute of limitations, regardless of when he was served, 6 years, because the cause of action wasn't timely filed. You know, I want to make sure that I'm not losing something in the translation.
Well, I think I understand what you're asking, Your Honor. And I think, I mean, there has to be subject matter jurisdiction and personal jurisdiction over a party. And so there's no question there's subject matter jurisdiction in the trial court. But there is a lack of personal jurisdiction over Mr. Campion because it's only acquired by service.
Does the statute of limitation deal with the personal jurisdiction by service, or does the affirmative defense of the statute of limitations expiration deal with whether the court can exercise its subject matter over that cause of action?
I think the statute of limitations deals with both. It could be either, actually.
Okay.
It could
I understand.
So here, again, the claim is just brought too late, basically, because he was never served originally. His whole argument is relation back. Relation back doesn't apply unless you're already in the case. We're not in the case. Mr. Campion was never in the case, so there's nothing to relate back to. So, I mean, I really think it comes down to, yes, there's subject matter jurisdiction, but there isn't personal jurisdiction over my client, not on these claims. And I think the trial court got the right result and should be affirmed.
You still have time remaining, did you have anything else, or did you want us to move on?
Well, Your Honor, I would say too, again, just on the, it's not a proper third-party claim either. I mean, he cannot maintain a claim, any claim, against Mr. Campion without asserting a proper third-party claim under Rule 1.180, which he didn't do, and I think he admits that. So he's trying to save that by saying, well, I added him as a party under 1.170. But again, that doesn't work because he didn't argue that. He didn't argue that in his initial brief. If he had, I would have definitely have addressed it in my answer brief, but he did not argue it. So that cannot be considered. That cannot be considered here under the cases I cited before. I mean, that's well established in this court and other courts. You've got to raise the arguments that you want to have the appellate court consider in your initial brief. And if you don't, then you've waived it and it can't be considered. So that's what I have to say. If the honors have any further questions of me, I'll be happy to try to answer them.
I don't see any further questions. Thank you for your presentation. We'll return to the rebuttal. Counsel, you have your 5 minutes.
Thank you very much. I would not raise an issue or a question with respect to 1.180 versus 1.170 because the court did not rule. This came about because of the tipsy, what's that called, doctrine, saying that there is another ground for the court to where this court can affirm the opinion. And then I responded to that. So that is not a part, the court did not dismiss the action because of Rule 1.180, or else that would have been what I was appealing. The court dismissed it because of a purported statute of limitations problem. And I do have, actually, it's the finest known, I pulled this up, it's cited in my brief, finest known, 241 Southern 3D 203. It's a 2018 case out of the 4th District. It talks about the difference between Rule 1.180 versus 1.170. And this is really the exact same fact pattern to where there was a contract between two parties, and then they tried to bring in the owner, who's Hotman, saying that he was the agent and he's personally liable. And they said the same argument was made that Mr. Campion's making here. They talk about the difference between Rule 1.180 and 1.170H, and the court says we express no comment about whether. So they say, yes, it's proper to bring him in, saying he's personally liable. It's not a indemnification claim. There's no requirement that the party be an indispensable party, but they say we express no comment about whether finance might prevail on his claims against Hotman in his individual capacity. So when I named Mr. Campion as a defendant, that's when he was brought in as a party. And you've got these misnomer cases where somebody, they spell the name wrong, or they sue the wrong entity because of a vowel here or something like that. And they say, okay, does that relate back when you actually try to bring in the correct party? And there's cases that say, yeah, that does, when you made a mistake and it was the other side's fault or what have you. But I actually sued. I spelled his name right. I sued Richard Campion. You do a comparison of when the cause of action accrued and when I brought him in. And this situation, as far as I would say, again, I've never seen this. I haven't found a case where somebody just jumps in the case and then the attorney thinks, okay, then they voluntarily, if I'm wrong on that, then what should have happened is that there should have been a hearing down below and on a motion to quash, or this should have been, and then the court had the right to give, because it's a case management tool. I heard Ms. Bush argue that, well, if my argument were correct, then somebody could just file a suit and never serve. But that's not true. Rule 1.070J is a case management tool, and the court has discretion to extend it beyond 120 days. And so at the lower court, this issue had been litigated. The lower court had agreed that, him filing that was not a waiver. Then I would have had the right to ask for an extension of time to serve and serve him. But none of that played out. But I would be deprived of that, and the court giving me that opportunity to extend the time by the court affirming the decision for that reason, which again was not litigated below, and that was not grounds. And again, I'll go back to, I had no reason to put anything in the initial brief about the difference between Rule 1.180, which you bring somebody in for indemnification, or Rule 1.170H when you're suing them directly because you want complete relief. You don't want to have to file two lawsuits. And again, if I was wrong, just if an attorney there's certain ways to serve corporations, LLCs, and you've got to do it correct. You've got to, I think, serve like the agent, try to serve the agent on an LLC. Then you try to serve the managing members, and then you can actually serve the manager that's on duty if they're a restaurant or what have you. If an attorney messes that up, doesn't do it right, it could be quashed, but then they'll have the chance to come and get it right. And so if I was wrong about whether I had service on Mr. Campion or not, I still have the right to try to get an extension of time. That's completely different. The service issue, which again, the trial court did not dismiss it based on that, is completely different than the statute of limitations issue, which I satisfied that, and Ms. Bush agreed by filing it. And once that's done, then that's done. If I'm required to serve and the court says you got 5 more days to serve and I don't get it, then the case could be dismissed. But the court does have the right to extend the time. That's a completely different issue than the statute of limitations. And also, the case law is clear, and I would say the venue cases are even clear, to where they say, listen, a court cannot say there's no venue, but then rule on the merits. So the court can't say that Mr. Campion was not served, but then also let him prevail on the merits by dismissing it with prejudice. You can't have it both ways.
Expired.
I'm sorry?
Your time has.
Okay. Thank you very much for your time. Thank you.
Thank you both. We'll let you exit. Please, for those who are listening, don't bring anybody over yet. I need to do an administrative thing real fast.